Kudła case, it was a kind of milestone in the history of the European Court of Human Rights. Well, the European Court of Human Rights has discovered a very serious, let's say, illness in Poland, which is the length of proceedings, of court proceedings in Poland. And it was a systemic problem. We have to realize this context. In 1991, Poland became the member of the Council of Europe. And then in 1993, we started a serious and process of the implementation of the European Convention of Human Rights. In the 90s, well, the situation in the judiciary system was extremely difficult. Kudła focused on two issues. The first one is the length of procedure of the at the national level, pretrial detention. Pretrial detention in Poland at that time, it was never-ending story. It was without any, let's say, limits. And well, the situation in the prison system, lack of proper medical examinations.
Problem zastosowania i progu, jaki musi być, progu dolegliwości, jaki musi być wypełniony, żeby doszło do naruszenia artykułu 3 konwencji, czyli w tle tutaj był, czy podstawą tego zarzutu skarżącego było według jego oceny nieodpowiednia opieka psychiatryczno-psychologiczna, ponieważ główny zarzut skarżącego opierał się na tym, że ze względu właśnie na brak adekwatnej opieki psychiatrycznej, przede wszystkim w czasie tymczasowego aresztowania, w czasie przebywania w jednostce penitencjarnej, dokonywał on kolejnych prób samobójczych, co według zdania skarżącego, według argumentów skarżącego, to właśnie po stronie państwa jako podmiotu, który pozbawił go wolności, czyli będąc w kompetencjach niejako państwa, będąc pozbawiony wolności, zdaniem skarżącego odpowiedzialność za zapewnienie mu adekwatnej opieki medycznej, w tym przypadku psychiatryczno-psychologicznej, ale przede wszystkim psychiatrycznej, spoczywała na państwie.
Kudła spent quite a long time in prison. And well, he tried to commit suicide many times. Well, according to the doctors, they said that his health state is so serious that he should be outside of the penitentiary system. He should be treated in a normal, let's say, hospital, specialized hospital, because he suffered from a very serious disorder, psychotic disorder. Kudła case shows it was the best example of inhuman treatment. And also, well, the courts, they've been blind and deaf. And it was incredible to have in front of the court a relatively very young person with so severe, well, suffering so much, and without any proper reactions.
The case of Kudła against Poland was lodged with the former European Commission of Human Rights in 1995. It was registered, that means that it met the formality formalities attached to an application. The case was referred already with the admissibility issue to the plenary commission, which we may compare with the present Grand Chamber, because plenary commission would take over cases which were of importance, of some new legal issue or concerned issues of general importance. What prompted this? It was not Article 3, of which we'll be talking, but mostly Article 13 of the Convention. And then the Commission gave the so-called Article 31 report. It was a report given by the Commission under former Article 31, in which the Commission was a non-judicial, rather investigative body, so they did not give judgments, but they could express an opinion as to a violation of the Convention, which then depended in the previous system, was either confirmed by the Committee of Ministers, or the case went to the court, which decided independently whether there was a violation or not. The Commission decided that there was a violation of Article 3, but it was a rather controversial issue when you think about the number of votes, because it was by 14 votes for a violation and 13 against. So it shows that from the very beginning there was quite a lot of controversy and discussion, and it was not that it was a view which was shared by a big majority. There was no question regarding Article 5, paragraph 3 and Article 6, paragraph 1. The Commission was unanimous in its opinion that it was a violation. And again, next controversy came with Article 13, where the Commission decided by 19 votes, as far as I remember, to 8 or 18 to 9, that there was no need to examine, that it was not necessary, therefore confirming the previous case. I don't know whether it had anything to do with the fate of the case or what happened, but it was actually the last Article 31 report adopted by the Commission on the last day the Commission existed, because then it was dissolved. And under transitional rules, in the transitional period, when the new court already took over the cases, but there was some part of applications which still needed to be handled by the Commission. So it was the last day decision and the last report. Then the panel of the Grand Chamber decided to take the case up to the Grand Chamber, and it was mostly because of the Article 13 issue.
Auparavant, il y avait la commission et la cour, et la commission examinait la recevabilité des requêtes. Et puis, il n'y en avait que certaines qui arrivaient à la cour. Et donc, toutes ces questions de recevabilité, c'était la commission qui avait une position parfois extrêmement dure sur la question de la recevabilité. En même temps, la commission faisait, je trouvais, un très très bon travail, mais sur la recevabilité, il faisait en sorte que des tas d'affaires n'arrivaient jamais à la cour. La nouvelle cour, c'était quand même un changement assez radical, ça c'est certain, avec à la fois des anciens membres de la commission, des anciens juges et 20 nouveaux. Donc c'était quand même, on n'était pas 47 à l'époque, on était moins, puisque ça s'était agrandi avec le temps, avec des nouveaux États qui sont arrivés. Mais il y avait un relatif équilibre entre les anciens commissaires, les anciens juges et les nouveaux. Les nouveaux sont venus avec d'autres préoccupations. C'est tellement clair, c'est avec d'autres préoccupations. Et ces préoccupations de la détention, c'est vrai que moi je les voyais pas partagé par beaucoup, mais c'était tout d'un coup un terrain favorable. Parce qu'à la fois, il y a une jurisprudence, et on doit suivre la jurisprudence, parce qu'on n'est pas tout d'un coup comme ça des faiseurs non, on doit suivre un peu aussi ce qui est toujours fait, parce que c'est un peu une sorte de fidélité au précédent. C'est un peu aussi une question de sécurité juridique, on ne peut pas tout chambouler comme ça, ça n'a pas de sens. Mais en même temps, on doit pouvoir ouvrir des nouvelles voies. Et la question de la détention était pour moi un exemple tout à fait, une situation tout à fait évidente. Mais alors, Kudla, ça c'est encore très particulier. Et j'allais dire, c'est peut-être un peu la petite histoire, mais souvent avec les petites histoires qu'on fait des grandes histoires. Hein. C'était le 50e anniversaire de la Convention. Et alors, il y avait une conférence diplomatique à Rome pour célébrer ce 50e anniversaire. Et alors, la Cour disait qu'il faut absolument qu'il y ait un arrêt vraiment significatif pour le 50e anniversaire. Et voilà-t-il que Kudla est arrivé. Et alors, vous avez, et moi aussi, j'étais très attentive dans Kudla, la question du bien-être des détenus. Mais Kudla avait un tout autre champ, c'était pas ça. Tous ceux qui ont estimé que Kudla était vraiment un arrêt fondateur, c'était en ce qui concerne le recours de l'article 13. Et donc la question de la détention est parue un petit peu, pardonnez-moi de le dire, secondaire. Donc on a été moins attentif à cette question, et c'est comme ça que ce qui est vraiment, pour les droits de la détention, une avancée formidable, est passé relativement aisément parce qu'on avait l'esprit tourné sur peut-être autre chose, qui était l'idée de ce recours, l'utilisation de l'article 13.
The whole issue concerning Article 3 concerned the quality of medical attention and medical care, and whether his needs were taken into account, in particular as the applicant twice attempted to commit suicide. And doctors' reactions were, different. There was conflicting medical evidence. So the government were asked to provide the court with all the medical records, and this, I think, helped the court to decide on the case. And I think that it was decisive that the medical evidence showed that actually authorities did what could have been required of them in the circumstances, and then they made available to him psychiatric consultation. Maybe he didn't get attention whenever he asked, but still the quality of it and promptness and the nature was found by the court to be sufficient in the circumstances of the case. So finally, the court decided that the level of severity, although the court, of course, confirmed that his state made him more vulnerable, that his mental state certainly compounded the feelings of suffering, and that he certainly experienced distress, but still found that the level of severity had not been reached.
Trybunał nie stwierdził w tej sprawie, orzekając Wielkiej Izbie, w składzie Wielkiej Izby, nie stwierdził w tej sprawie naruszenia artykułu 3 konwencji. Takie stanowisko skarżącego, że w momencie, kiedy państwo obejmuje kogoś pozbawieniem wolności. Państwo, oczywiście używam tutaj wielkiego skrótu, chodzi o odpowiednie organy, które w odpowiednim trybie spowodowały, że osoba jest w jednostce penitencjarnej, czy to ze względu na wykonywanie tymczasowego aresztowania, czy ze względu na wykonywanie już kary pozbawienia wolności, czy też wykonywanie jakiegoś izolacyjnego środka zabezpieczającego, mówiąc szerzej. Więc w tym wyroku bardzo mocno to wybrzmiało, że powodem, krótko mówiąc, nie dlatego doszła tam do stwierdzenia braku naruszenia artykułu 3 konwencji, że państwo nie odpowiada za odpowiednią opiekę medyczną osób w jednostkach penitencjarnych, tylko dlatego, że w tym konkretnym przypadku stwierdzono, że ta opieka zagwarantowana czy oferowana tymczasowo aresztowanemu panu Kudła ze strony państwa była wystarczająca, nie była nieadekwatna w stosunku do wymogów artykułu 3 konwencji. Natomiast dla mnie kluczowe było w tamtym momencie, że wybrzmiała ta zasada, że w momencie, kiedy państwo obejmuje czy pozbawia człowieka wolności, to za niego odpowiada. Odpowiada za jego bezpieczeństwo, odpowiada też za dostęp do adekwatnej opieki.
When you look at how the court goes about it, how the court starts its analysis, it repeats its old case law, also confirmed in more recent court's rulings in V versus the United Kingdom and in Labita, starts from Article 3 being enshrining the most fundamental values in democratic society. It comes back to the level of severity which is required for treatment to fall within the scope of Article 3. Again, it repeats the old case law, saying that the assessment of the level of severity is in fact relative, that it depends on the circumstances of the case, on the context of treatment, on the manner and the execution of the measure complained of, duration, physical and mental effects, and also specific circumstances of the applicant, be it age, sex, and state of health. And then it recalls that, in fact, suffering and humiliation are often, in fact, can be connected with any given form of legitimate treatment of punishment. And on the basis of this, the court confirms that, yes, the measures the person deprived of liberty inevitably suffers, and inevitably there is humiliation involved in this. But what the court says later is more important. It says that, in fact, there is a positive obligation on the state to ensure that the person is detained in conditions which are compatible with respect for his human dignity. So I think that this is perhaps the new element, which perhaps didn't look that new for the judges who tried the case, because it was the strand of the case law already existed. It was rather like synthesizing the court's case law and looking at it in a more holistic and global manner, I would think. And the second, this obligation is twofold. So the first one is to respect, is that the conditions of detention must be compatible with human dignity. But second is that they have a duty to ensure that the prisoner's well-being and health are adequately secured. And saying, well, this was a case concerning a mental health problem, by providing the requisite medical assistance. You referred to Erd's judgment, but Erd's was not extremely helpful in this statement, because Erd's did not say what is actually said in this famous paragraph of Kudła, and it cited mutatis mutandis. As this case resembled Kudła in one aspect, actually, that it concerned a question of treatment to be provided to a person suffering from a mental condition. So actually, Erd's comes not in fact as a authority supporting, but illustrating the particular situation that we are talking in this situation of a person who suffers from a mental condition. What it changed? I mean, when I think about it, the court was rather restrictive before. So, and there were not so many cases concerning prisoners' rights or conditions of detention or problems of health or mental health even in detention. Commission, on the other hand, confirmed that, of course, that the health and the well-being should be secured during imprisonment.
Kudła versus Poland judgment was very, I think, was very important as a matter of principle, because it showed the turn of the court to the actual prison conditions and to the potential for the violation of Article 3 by the failure of a state to exercise its duty of care for the persons who are placed in penitentiary institutions. And this also opened the huge, I think, part of work for the court, where the court started addressing the issues in both in various countries on a case-by-case basis, but also systematically through pilot judgments. For the CPT, it meant that the CPT has received a very strong ally in the court, which was exactly the intention of the drafters of the CPT convention.
The court does not really look forward very much to the future. The court decides on the case before it. So statement in Kudła was then taken up in many other judgments, and it's still cited. So it seems that the Kudła test withstand the time. So it's a kind of a general statement on the basis of which the court defined further obligations of the state. So from this one positive obligation, there are many other specific duties on the prison authorities. And it is true that in 2000 there was an abundance of judgments, that it was like a big start. The beginning, let's say between 2000 and 2005, there were many judgments which referred to different aspects of prison life. And when you look from Kudła and this positive obligation to detain a person in human conditions, and then you go in 2005 to Hearst number 2. Against the United Kingdom, when there is an affirmation that prisoners enjoy their fundamental convention rights and freedoms in prison, except for the right to liberty if it is executed by a legitimate punishment and falls within the scope of Article 5. And then the court went on to make a whole list of rights of prisoners that they can exercise, may exercise, and should exercise in prison, in order to further justify its conclusion that the right to vote is one of such rights which can be exercised in prison, and there is no inherent limitation in the convention on this right. So I think it is interesting to see all the developments in the meantime. So there were many cases concerning demands of security in prison, but then you would also see development from Messina to Van der Ven, that there are limits to intrusion on the prisoner's private life, there are limits on prohibiting contact, even though you have the most dangerous prisoners. And this line then will be again taken up in many other cases concerning security in prison in the years of 2010, 2012, and till now. It was the time where more cases came from the so-called new countries. So there was Russia, there was Ukraine, Moldova, and so on, joining the convention system. And I think that Russia and then Ukraine brought something which then became a kind of anathema of the court. It was the question of prison conditions, but really minimum prison conditions that could be required. And Kalashnikov was one of the cases which revealed the tip of the iceberg, with which the court will have to grapple later. And it was the first case disclosing a systemic problem. It was not called as such in the judgment, but everybody could see that there is a great issue where that before we go to even to right to vote, with all respect for other rights, there is something so basic like having a bed in prison. Of course, Pierce also was kept in very poor conditions, but even though it was quite widespread in Greek prisons, what was the case in Kalashnikov described a situation which was far more desperate. And in fact, the defense of the Russian government was quite telling and quite, I would think, a warning for the future, because what they said, and at that point there were nearly a million inmates in Russian prisons, they said, well, there was no intention, of course, to humiliate or make Mr. Kalashnikov suffer. I mean, it's just his conditions of detention are not any different from any of other inmates. So this was something which I think gave the court the first warning that it's going to be confronted with far reaching issues and very difficult, which are not going to be handled only by a single judgment finding a violation.
Kudła is a kind of quasi-pilot judgment. The court decided to say clearly that the judicial system in Poland is very ineffective, that it needs an improvement, and the legal standards at the national level are totally different than international standards. And Kudła, it's the picture of a clear picture of the violation of so many provisions of the European Convention of Human Rights. Article 5, paragraph 3, Article 13, Article 6. But the basic issue, and this is the dominating, let's say, line of Kudła case, was, well, the court said that citizens in Poland, they do not have a proper legal instruments which allow them to complain in case of the excessive length of proceedings. So it was interesting that court was quite clear about it, and it was also a very strong opposition of the government. The government said, well, we have other, let's say, means, legal means, like a civil code, and we can go, such a person can go and can get a compensation through the legal code. But the court said, no, it was a clear violation of these articles, and it means that Poland was, through this judgment, was forced 20 years ago to adopt a law.
I remember that it was one of those first cases which showed like an important context of length of proceedings in Poland. And what was especially important in this case, in my opinion, is the use of Article 13 of the Convention, and showing that lack of effective remedy, allowing for fight against unreasonable proceedings, is something that is violating the Convention, and that Poland basically should introduce this remedy. I remember that at that time there were like hundreds of Polish people that were submitting complaints to the European Court of Human Rights, claiming that Polish law violates Article 6 of the Convention because we do not have any remedies.
Dla mnie, i uważam, że też myślę, że dla doświadczeń polskiego systemu wymiaru sprawiedliwości, precedensowy charakter tego orzeczenia, czy jego absolutnie nieporównywalna do innych waga, wynikała ze stwierdzenia naruszenia artykułu 13 konwencji, o czym jeszcze nie mówiłam, bo oto po raz pierwszy w tym wyroku Trybunał, orzekając w składzie Wielkiej Izby, powiedział, że musi być dostępny dla skarżącego środek skuteczny środek odwoławczy także w przypadku naruszeń artykułu 6 konwencji, które polegają na niezapewnieniu prawa do rozpoznania sprawy w rozsądnym terminie. Argumentowaliśmy wówczas, że Artykuł 13, zastosowanie artykułu 13, czyli uznanie, że potrzebny jest skuteczny środek skarżenia się na przewlekłość postępowania, byłoby dodaniem wymogu proceduralnego, wymogu istnienia środka odwoławczego do prawa, które samo w sobie ma już charakter proceduralny. Były takie obawy i były takie argumenty, że rzeczywiście, jeżeli mamy postępowanie karne, które się toczy, pozostaje przy przykładzie postępowania karnego, ponieważ jest ono mi najbliższe, że wprowadzenie takiego dodatkowego środka incydentalnego, wpadkowego skarżenia się na przewlekłość wydłuży samo główne postępowanie. Takie obawy były, z całą pewnością był to też element argumentacji rządu. Trybunał nie podzielił tego zdania i z perspektywy czasu bardzo się z tego cieszę. Wtedy być może uważałam to za porażkę kogoś, kto reprezentuje jedną ze stron, ale teraz uważam to wszystko, co nastąpiło później. Powszechnie ustawa znana jako ustawa o skardze na przewlekłość, która zaczęła obowiązywać od 2004 roku i samo uchwalenie tej ustawy było pewnym przełomem.